ecosystem and the governance of digital communication networks or social media in India, among other things. I would like to thank both Vrinda and Prateek for joining us today and offering to provide their insights of the bill. Now, quickly coming to the structure of the call, we will begin with a 40-minute briefing by the speakers. This conversation will also be publicly live streamed. This will be followed by a 20-minute block only for members and donors on call for answering their questions. Please keep in mind that we will stop live streaming as soon as the briefing ends. So if you wish to gain access to our exclusive Q&A section of the briefing calls, all of them, so please do consider donating to us. Your contribution literally keeps us going and no amount is too small. Please consider supporting our work and we promise to keep working hard and delivering. Prateek, before I hand this presentation over in your capable hands, let me just inform everyone that IFF has released its statement and an initial analysis of the bill on our website and across social media platforms. For a quick read, please consider going through them if you haven't already. Someone should be sharing the links as I speak. Over to you, Prateek.
Thanks, Tejasi. When we set up this call, I don't think we had anticipated that we'll be in a situation where the bill has already been passed in the Lok Sabha with just a 52-minute discussion, and I think something approximately 9 MPs spoke if you also exclude the union minister, right? And I think over the next couple of days, people will be picking apart what everyone said, and we'll see what happens in Rajya Sabha. But if you can just move over to the next slide, and I think this is something that's right? Especially if you've been on one of calls before, this timeline that's been going on for a while. It looks like we're somewhere. Can you hear me? I just got a message that my internet was unstable. Okay. Yeah. So it looks like we're at a point where we can maybe check off this timeline for now. But look, ultimately, that number of issues I think to unpack. We'll also look at some of the clauses that the bill does bring in that are worth thinking through a little bit more. So let's start with, I think, the consultation process itself, right? And I think this is something that we've raised a lot of concerns about. If you go back, it's almost poetic in a way that it was introduced exactly a year to the date where the DPB 2021 was withdrawn. I don't know if it was poetic good or poetic bad, but it was just poetic. But look, so if you go back to that, right, it was never really clear in terms of why the previous version was withdrawn, what the rationale was, why the scope completely changed. There wasn't, apart from the mention of, okay, there were amendments to a number of the clauses, and so it was easier to rewrite the bill. Still, the changes weren't really, at least the reasons for a lot of the changes weren't really articulate, right? But nevertheless, we did come to a stage in November where the 2022 draft, right, was put out for public consultation, and I think I just want to raise a couple of flags here in the sense that, especially over the last couple of days, we've heard a number of times that the consultation was wide and exhaustive, and so just a few things on that, right? And if you look at the standing committee report that tabled during this session, I think the number that we get is 45 government departments and ministries have given comments, and 21,666, no coincidence there, number in terms of stakeholders that have provided inputs, right? And despite that, it's still unclear in terms of the nature of comments that came in, again, why certain provisions were changed the way they were, because the ministry has refused to put these out in the public domain. They've also refused to share them under an RTI request. So we don't really know in terms of why things have changed, why certain new aspects have been introduced, some of which we cover, why certain things have gone away, right? Also some question marks in terms of some of you may have seen the news about opposition members of the opposition, who were in the Standing Committee of Information Technology, walking out from one of the meetings because the bill was being discussed. Right now, it's the 2022 draft, or it was never really formally introduced or formally referred to the parliamentary committee. So it is strange that they took the approach that they did. Nevertheless, that's now I guess water under the bridge, and we are where we are. Right. The other thing that's also worth looking at is the fact that the bill identifies 25 matters for rulemaking and a 26th, which basically says that it can expand it to any other matters. Some of them I think are legitimate, but broadly the net effect of having so much left to executive rulemaking is that it is unclear to really unpack what a lot of the consequences of the bill are going to be, or when it's an act, what is going to be. It's also unclear, while the bill does say that the rules will be then introduced in Parliament as they should. It's also unclear if there will be consultations at that stage. And we've also seen how rulemaking power sometimes plays out. If you look at, especially we've been following some of the developments around the IT rules 2021, subsequent amendments to those. There is a tendency to be what's the word, right? A little to borrow the legal term, I think ultra vires, right? When you look at the scope of some of the rules. If we can move on to the next slide. Having said that, I think it's still important to look at what some of the provisions are, right? Now it does have a provision for to provide notice. Now what this really translates into is that every time there is a request to a data principal for consent, it either has to be preceded or accompanied by a notice. And if let's say it was taken, consent was already taken in the past, they still have to do a notice, issue a notice after it is enacted, right? Which will include personal data of a data principal, what personal data and the purpose for which it will be processed, how to withdraw consent, and how to seek grievance redressal under the mechanisms that are proposed, and how to file a complaint with the data protection board, right? And the data fiduciary can then continue to then process this data until such time as the data principal withdraws consent. We will cover exceptions, but it's just something to note that the way exceptions are sort of littered around across the bill, there is a provision for for certain class of data fiduciaries to be exempted from the obligation to provide notice. If then the next thing to look at is the establishment of the consent framework. Now the language of the bill says that it needs to be, and I'm going to read out here because I obviously don't remember it all. It needs to be free, specific, informed, unconditional, and unambiguous, with a clear affirmative action, right? And it has to be signified by an agreement from the data principal. Now it says it's meant to be limited to the personal data which is necessary for a particular purpose. So there is, in theory, a purpose limitation aspect to it. And if, let's say, if this is used to obtain, I think some part consent which goes against the act, and I think the illustration that's given there is if while providing consent you also give up your rights to seek redressal, go to the data protection board, then that particular part is going to be invalid because that's not permitted, right? And it has to be presented in English and any other languages. In the 8th schedule, you have to provide, the data fiduciary has to provide the contact details of the data protection officer or an equivalent officer. And I think this one's interesting that, okay, consent can be withdrawn, and the mechanism for doing so should be, in terms of ease, comparable to how easy it is to give consent. The consequences of withdrawal need to be borne by data principle. That's an interesting one in terms of how that can really play out, how data fiduciaries use that to keep either to keep processing data or to then deny services. I think we'll have to see how some of these play out. Right. I know we'll probably come to rights a little later, but it does provide some rights, and Kartavya Kal, it also puts duties. It does place obligations on data fiduciaries, and these are broadly split into three kinds. There is a general set of obligations. There is specific obligations for when it comes to processing data related to children, defined as people under the age of 18 under this. Unless it changed with today's version that I don't think that's been published yet, but I think till the last version I saw it was under the age of 18, and specifically, and also for significant data fiduciaries, right? I don't think I'll go into each of the types of obligations, but I think it's fair to say that there are some number of them in terms of having to comply with the act, implement processes to do so. They can engage a data processor only under a valid contract. There is an obligation to ensure completeness, accuracy, and consistency when data is used to make a decision about data principle or being disclosed to another data fiduciary. Again, this will come back again probably when we're talking about exceptions, right? There's also a need to notify data principles in case of a breach, and I think this was something that came in the 2022 draft, and it's good to see that at least that has been retained. There is the need to protect data under its take reasonable security safeguards, and of course if you also have to publish information about the data protection officer or whoever equivalent authorized officer, right? And the one thing that's interesting is, and this will play out with the right to erasure, is that they do have to erase data when either when consent is withdrawn or a data principal exercises their right to erasure, assuming retention is not required or not necessary for lawful purposes. And again, it's going to be interesting to see how that plays out when you think of things like the certain directions or or the need to retain, I think, financial transaction records for 10 years and things like that. How that's going to play in, what the interplay of that with the withdrawal of consent or the right to erasure is going to be something we'll have to see, right? Specifically with children, I think a couple of notable things to point out, in the sense that there is a need to obtain verifiable consent. And I think this, depending on how it gets implemented, could have significant ramification. Is it going to play out as an age gating mechanism across the internet? Are we going to take video selfies to access sites, etc.? Right. So this is going to be one to watch out for. They cannot process personal data that is likely to cause and I'm going to quote from the bill because I think that language is important. Any detrimental effect on the well-being of a child. Earlier version said harm to a child. This is a sort of change, but I think in terms of what this means, that still needs to be established. There's an obligation. You cannot track or essentially tracking or targeted advertising is not allowed. Side note, I would recommend reading this book called The Subprime Attention Crisis by Tim Huang. I won't go more into that, but it's an interesting take on what happens when you try to change the model that's underpinning a lot of these services. And there is, of course, discretion in the form that the union government can exempt the obligation to look for verifiable consent or limitations on tracking advertising if they're convinced that the processes are verifiably safe. Again, it's unclear what that means, right? When it comes to significant data fiduciaries, again, there is the ability to notify them, a data fiduciary class of them, on a number of factors. Such as volume and sensitivity of data. I think you can understand that. Risk to rights of data principle or the electoral democracy. Then they get interesting in the form of potential impact to sovereignty and integrity, security of the state and public order. So again, it gets a little fuzzy in terms of how that'll really play out. And then there are some obligations in terms of having to appoint a data protection officer that reports to a board or equivalent body. They need to do data protection impact assessments and audits, and potentially other obligations that can still be prescribed. Right. And I think from the appeals process, one significant change, I guess, to highlight is that, and probably something to try and unpack later on, is that beyond the data protection board, where you can go, so there's a grievance redressal at the data fiduciary, you can appeal to the data protection board, and then you can appeal to the telecom dispute settlement and appellate tribunal. It's unclear to me why this particular tribunal was chosen. And I think there are questions of whether it should go to a tribunal or whether it should go to a court. I'll probably leave some of those aspects for Vrinda to unpack. But I think those are still interesting questions to look at.
Thank you, Prateek. Now, coming to you, Vrinda, government exemptions. This is something that's been talked about fairly a lot, right? Since I would say the very first or second iteration of the bill. What does the exemptions look like in the current iteration, in the 2023 version, and what are the implications of these exemptions?
Yeah, thanks a lot. So one, as you've sort of already mentioned on the slide, like a big change is also just broadening the applicability of the exemptions. So for instance, in the 2022 draft, which you've got on the left, right, it was the notified, what would happen is that any notified instrumentalities of the union government would have been exempted. So you would imagine these are effectively agencies of governments or departments of governments, which would be, we were expecting this would be like your ED or any other CBI, any other government department, some ministries that would be exempted. This has now been expanded because now any processing that is done by the central government as well on information that is provided by a government agency. So it is not, so the government agency will give the central government some data, and now that data also gets exempted. Now, the problem with the exemption sort of has remained the same, right? Which is throughout, which is that if you look at 17.2A and 17.3 especially, it says the entire applicability of the Act. Can you just go to the previous slide, sorry? So the entire applicability of the Act is exempted. Unlike 17.1, where at least some security safeguards are there, some basic safeguards are there. Here, the entire Act gets exempted for the processing of any personal data by any such instrumentality of the state, right, which the government can notify, which is effectively any agency of government that you interact with. And you also should see this in the context of the new date, the births and registrations bill that's also been tabled in the Lok Sabha, which is also seeking to sort of, connect your Aadhaar and link all your portals, link all your data across different portals like passport and ration card and electoral rolls. So see all of these acts together. I think that's very important. And so you then have any instrumentality of the government, which will be exempted from the Act as long as it's in all these broad interests of sovereignty, security, friendly relations, public order, which is going to be the biggest factor, as well as preventing incitement to violence, right? So this means that the government can effectively decide when to exempt itself or any of its bodies from the application of this Act. And it just says, and the processing by the central government of any personal data that it may furnish. There is no procedural safeguard that is provided in this bill at the moment that says that, look, you should follow necessity, you should follow proportionality. The 2018 version put by Justice Sri Krishna, even that was sort of criticized for, like, do you really want to include these sort of surveillance provisions and these broad exemptions? Even that at least mimicked the language of Puttaswamy. And I think it's very important to say on the ground why it's necessary that your law should say that any such exemption should also be done in a proportionate manner. It should be done in a narrowly tailored manner, because otherwise what it means in practice is if the government agency comes and takes all your data, right? And there are no provisions, so they don't even have an obligation to secure that data. So they are collecting all your financial records. Imagine an income tax raid or something. All your financial records are good. There is not even a minimum obligation on the government to safeguard that data. There is no prohibition that is mentioned in the Act expressly that data cannot be shared with other agencies of government, right? These are exemptions and these are restrictions and safeguards that should be built inside the Act. It should be said, you should only ask data from me that you need. there should be some kind of collection limitation, right? If you are investigating my offenses for, say, the last 1 year, you don't need data necessarily for the last 10 years, right? Or if you're looking at some speech I've made online, or some Twitter post that I've made, or some WhatsApp post that I've made, you don't need like other information about my foreign travels, for instance. So I think the fact that none of these exemptions apply, the fact that there is no actual writing that says apply it using Puttaswamy standards, means that on the ground, when this exemption is happening, it is then going to be left to somebody having to raise that issue, to them then say, to the government then saying, no, this exemption is not clear. And then you effectively have to go to court. And unfortunately, what happens on the ground is very different from the reality in the law. So I think that's why it's very sad. Like, it's very sad that we've not moved beyond this and that we've not been able to improve on this provision, despite all sorts of the debates that have happened. Then I'd like to, if you could go to the next slide. The second exemption is any exemption for research, archiving, and statistical purposes, as long as the decision is not being used to take against the data principle. So the logic behind this effectively is, when you collect statistical data in India, like your NSSO data, your household data, your survey data, as long as, no personal decision is being made against you, that, you obviously, it's not often possible to get consent. So that's the, that's sort of the rationale for that exemption. 17.3, according to me, is also pretty worrying, although most people have been focusing on 17.1, because 17.3 allows the government in the future to decide, having regard to volume and nature of personal data processed, which data fiduciaries are exempt from most of the provisions of this act. Now, there is no rationale that we can find as to what does volume and nature of personal data mean. So does it mean that very small companies will be exempt? Does it mean that very large companies will be exempt? All we know is including startups. Now, the definition of startup is actually very broad, right? It just says it's any limited liability partnership or private limited company which is eligible to be recognized in accordance with criteria and processes that will be notified with the department in the future. So we don't know who these startups are. Many startups today, in fact, are the ones that collect the most data, right? And just because it's a startup doesn't mean, like, are you defining it in terms of profit? Are you defining it in terms of valuation? What do you mean by volume and nature of personal data? So I actually think this provision will also allow government companies to seek wide-ranging exemptions. And I think that's even more worrying because, these will be hidden behind some government notification that comes out and we have no means. And even if you talk about delegated legislation, what is the principle that the law has laid for the executive to decide? So I think this is actually, again, a very, very problematic provision. And then in respect of processing by the state on any instrument, I think we can, sorry, it's already 7:23, so I'm just a bit cognizant. But we can probably sort of focus, we can go to the next provision. The only thing I'd like to say is that central government, so 17.5 says that the central government before the expiry of 5 years will have to declare that any provision of this act shall not apply to any such data fiduciary for which it decides. So again, we have no way of knowing in what way this power will be used. So when you think of exemptions, I just want you to think of two things. One, the power being exercised by the state in our interactions with the state. And remember, these don't necessarily have to be in the criminal context. Like I've given the example of ED or CBI or income tax, but I'm also just talking about your everyday interactions in terms of your passport renewal, your, ration card for those who would require that, your driving license. So think about the power exercised by the state and then the power that the state has to decide which businesses will get exemptions from vast provisions of the act, such as like notice, consistency, all of that stuff. Can we go to the next slide? Now, at least all these provisions are branded under exemptions, right? So, the entire act doesn't apply. But I think Section 7 is probably even more interesting because this is the rebranding of deemed consent or an exception to consent. So rather than an exemption, it used to be what is an exception or deemed consent. Now they've certainly just said that the data fiduciary can process your personal data for any of these legitimate uses. And these legitimate uses, interestingly, it's not used in the text. It's only in the side note that they use this for the specific purpose for which I have voluntarily provided my data to the, data to the data fiduciary, and where I have not indicated that I do not consent. So here, what has happened is that effectively, and can you go to the next clause as well, 7B? I just want to take all of them together. Can you go to the next slide? Sorry.
So
We don't have
7B.
right? Okay, that's fine. I'll just talk about it. So 7B is actually even more problematic. Can I share my screen on 7B or not? Will it be possible? Or you would stop your screen sharing? It's fine. Forget it. It's fine. So 7B for all of you who's online, if you can just open 7B, and if one of you can just copy paste the text, please, on the chat box for those of them who are following online. 7B essentially allows the state. So any data fiduciary, so any company or any state can process my personal data when it's the state context, if it is to provide me any subsidy, benefit, service, certificate, license, permit, where I have previously consented. So once I have consented for the processing of my personal data by the state or by any instrumentality of the state for any certificate or license or permit, that consent is deemed to continue forever, right? So that's, I think, very problematic. That is definitely not a legitimate use. And more importantly, where this personal data is available in the digital form or in a non-digital form in any database which is maintained by the state. So as long as my name is in some state database, all our names are in various state databases. As long as my name is in some state database, the law seems prima facie. A reading seems to simply be that, you are exempt. This is considered a legitimate use, and hence the state can process my personal data. So I give my data in the Aadhaar database, right? We've all had to get Aadhaar. So our name is in the Aadhaar database. Does that mean that personal data can be processed for any other purpose, as long as just because it is part of a database? So I think, again, this is a really problematic provision. I think it's also one of those things where everybody's talking about exemption. And so I feel Section 7 hasn't gotten as much attention. So I do request each of you to go back and look at Section 7 as well, because in a way, Section 7 will affect all of us in our daily lives much more than the exemption provisions are. And so I think it's very, very important. The only safeguard right here is that it's subject to standards that will be followed for processing in accordance with the policy issued by the government or any law enforcement. So again, no procedural safeguards that are mentioned. And the illustration that they give is simply just that if you're a pregnant person who enrolls yourself on an app to attain any maternity benefit program, then that personal data may be processed to determine my eligibility to receive that or any other prescribed benefit. What they don't actually give you an illustration is for 7B, 7B2. And I think that is really sad, like kind of problematic, because it doesn't illustrate the dangers of the provision. The one good thing that I think has also been mentioned in the slide is that at least remove the word public interest, which was very vague. We will come to this later when I speak about blocking, while it's good that it's been removed from here, it's come in the blocking provision. But I think for right now, since it's 7:30, I'll sort of end on this deemed consent.
Thank you. Thank you so much, Vrinda. Prateek, now this particular version, and even the 2022 version that was released for public consultation, did something very interesting, right? It introduced duties, as you previously mentioned. Is this something that we've seen in previous iterations or in comparative legislations internationally? Could you maybe shed some more light on this?
So to my knowledge, I don't think we've seen any other equivalent data protection legislation anywhere that imposes duties on us. So it's an interesting innovation, I guess. If I'm playing fast and loose with that term. But look, I think it's also important to recognize that yes, it does give us some rights, and I won't take a lot of time. It says that you can request for the personal data it has and the type of activities that are being performed on it. The identities of data fiduciaries, which again was earlier required as part of notice, now it's been removed from notice, but you can still potentially request for it at this stage. And it says, there's certain other information. What it does have an exception in the sense that there won't be any disclosure if it's something that's required for investigation of cyber incident or offenses. So in that case, that information will not be provided when you're exercising this right? And there's also the aspect of right to correction and erasure of personal data, which is again, as the name implies, you can ensure that information about you is updated or removed. Again, I'll go back to the point about erasure being right to erasure being fairly limited across, in the sense that, look, if it's required for retention under for some purpose under law, then there's really no obligation for them to erase that. And I think if you go back to the exemption clauses, then for government instrumentalities, it's pretty restricted in that sense, right? So there is right to erasure, but I think the way it's going to play out is going to be something that we'll have to see. Grievance redressal we've already sort of covered, so I won't go over that. And nominate is that, in the case of death or incapacity, you can nominate someone, as the slide points out. Data portability, right to be forgotten, things like that aren't there, right? The duties one are pretty interesting, in the sense that, look, you have to comply with pretty much, as the wording says, all provisions of all applicable laws for the time being enforced to exercise your rights under this one. Again, you can't impersonate another person. Not to suppress any information and this is interesting, for any document, unique identifier, proof of identity, or proof of address issued by the state or any of its instrumentalities. Now, so it does seem to be narrower in my plain reading. I'll leave it to the expert there, but in my plain reading, it does seem to be narrower than what was in the 2022 draft. It's still problematic in the sense that, if you look at it, on the one hand, there's effectively no right to erasure against when it comes to state instrumentalities, and you're also duty bound to give them information, right? So it's an interesting balance over there, right? And then there's stuff about you have to provide information that is verifiably authentic, and this is the one that I think could play out the most, is not register false or frivolous grievances or complaints with the data fiduciary or the board. Again, there's no clear definition of what false or frivolous is going to be in that in that context. And if you don't follow your duties as per the law, you can also potentially be penalized up to 10,000 rupees. I think that's what the schedule specifies. Right. I think I'll pause there. We can move on to the other portions. I'm also maybe going to give us 5 minutes extra if we need it.
Okay. Thank you, Prateek. Okay, now, Vrinda, we've spoken about duties and penalties and rights. So I think it naturally flows into the conversation about the Data Protection Board, and generally the concerns around its independence. Would you like to touch upon that, maybe?
Yeah. So I think just from where Prateek is talking about frivolous complaints, right? So I think it becomes important when we see frivolous complaints to the Data Protection Board, and sort of what is the Data Protection Board. So I think just to understand, so the Data Protection Board today has all these adjudicatory powers. The one good thing is they've sort of removed the regulation and adjudication function, which is actually a good thing because it reduces conflict of interest. But so the Data Protection Board is the most important entity in the success of the act. If you actually see in practice, will this act be successful 5 years from now? That will all depend on the Data Protection Board. Is it an activist board? Is it a conservative board? Is it an independent board? Is it a pro-business board? Is it pro-civil, sort of citizens board? How is the composition decided? Is it, does it do a lot of suo motu investigations? Does it only act on complaints? So the success of the board, the success of the data protection journey will sort of depend on the success of the actions of the board. All these provisions will be irrelevant if we don't have a board that's actually functioning fairly. And I think that's why there's been so much concern about the lack of independence, because effectively, as you see, the central government shall decide how many members, so how big the board there is, shall decide who the members are, who is the chairperson, and who the members are. It's going to be simply the central government. There's not going to be any sort of selection process in that sense. There's not going to be any, any consultation with either leaders of opposition. Sometimes these selection committees, and one of the drafts, I think, had the Chief Justice as well. So there's not any comprehensive selection provision. And I think that's really problematic, because while everybody talks about the provisions of the law, what's going to ensure its enforcement is the Data Protection Board. And when you consider that the state is the biggest data fiduciary, right? The state has the biggest amount of data. And if the central government is deciding again, these terms are only for 2 years. The terms of each of the chairperson and the members is up for 2 years, and they're then eligible for reappointment. So even when you consider sort of the incentive structures that line up, how do you functionally ensure independence? So one good thing they've done is obviously you can't change the salaries or allowances or any terms of service. But I think the fact that you're going to be reappointed every 2 years means that A, you don't even have much chance to make a change. And especially in the beginning, where I think in the beginning, everyone's just going to be learning alongside, right? We've never had a data protection board. So when you consider that if you were a chairperson or a member, would you be wanting to take on the government, or would you want to be more conservative? So I think when you consider that and the fact that there is no outside element and no external involvement in the data protection board and the independence of the board, I think it is very problematic. So yeah, I think that's on the board. That's sort of the only thing I would say. On blocking, sorry, are we doing the RTI later, Prateek?
Yeah,
I think we can come back to that. Let's just go to the blocking.
Okay, yeah, quickly.
We'll go back.
The blocking provision, I mentioned earlier that it's a good thing that they've removed public interest from the legitimate use exception. Unfortunately, they've brought it back here. So now we have this complicated idea that we have blocking under 2 laws, right? So we have blocking under Section 69 of the IT Act, 69A of the IT Act, and now we have blocking under a data protection bill. Not sure why we need to have blocking under a data protection bill, but be that as it may, there is now blocking under the data protection bill. And essentially here, if the board, this all-important board, advises the government, sends a reference to the government. So if you see 37(1)(b), that in the interest of general public, that it is in the interest of general public, then the central government can effectively block the access for any such information, that's online and that is enabling the data fiduciary to carry out its activity. They do have these provisions that say the data fiduciary will be heard, but only when it is necessary or expedient to do so, or when it is in the interest of general public. So you would imagine, how would this work in an emergency situation? We don't really know. I also, just practically speaking, I'm not clear. So there's a substantive problem, which is why do we have 2 laws that deal with the same power? We also don't have in the law substantively here any of the safeguards that are built into the blocking rules in the 2009 blocking rules, which are upheld in Shreya Singhal. I have various objections to the way the blocking rules are drafted, but at least there is a procedural safeguard. We are able to go to court regularly and say, look, these rules have not been followed. So I think the existence of the rules and the existence of those procedural safeguards and in the text itself, in 69A itself, right, helps us. None of those procedural safeguards have been brought in at this stage in the Act. So we're not clear. So if you have, and then you have public interest, which is not a provision under 19(2) of the Constitution. It's not a, it's not a ground on which you can restrict fundamental rights. You then have one provision where it's easier to restrict or block government data in public interest. And then you have another one where you have to, do it in the interest of public order. And you have to sort of, follow the entire procedural safeguard, and you have to have a review committee and all of that. Which one do you think the government will use, right? So I'm just unclear in some senses as to why we needed 2 provisions. And I think if you have blocking rules here, then you have to either remove them from the IT Act, or if you have them in the IT Act, you shouldn't have them here. I don't think you can have them in both places because it's just going to result in unnecessary conflict. And especially because it's the same ministry that's administering both these laws. So I'm not really clear why we even need 2 provisions. And then the last one, which is actually on the applicability of the Act. And, this is something that's so easily missable. But it's very interesting because we've been talking about the pros and cons. And I think I would like to say, I think it's very important that India gets a data protection law fast, right? I think not having a data protection law in some senses is even more dangerous because right now there's just no recourse to many citizens against acts of, especially private companies. But who does this Act apply to? So it says the Act shall apply to the processing of personal data within the territory of India in a digital or non-digital format. And it shall not apply in 3C to any personal data processed for individual or personal use, which is absolutely correct. But it shall also not apply to personal data that is made or caused to be made publicly available by the data principal to whom such personal data relates. So let me give you 2-3 examples, and I unfortunately don't have the answers. The illustration only says that if I blog my views, then I've publicly made available my personal data on social media. So then the provisions of this Act shall not apply. So suppose I write a blog post about, which describes my caste or my religion or my political views, or which describes an incident of sexual harassment that I may have faced. All of that information, there are no personal data protections of the Act, right? That data can then be used by anybody. Does that also apply to data that I put on Facebook or Instagram? Are these data that is made publicly available? Or is it only if I have a private account, then it's not publicly available, but if I have a public account, then it's publicly available? What happens to data that I share, say on Strava, which is like a running app? Is that data publicly available? I think when you just consider, or to give you a sort of lawyer example, all our information, I'm an advocate on record, so all our information, our phone numbers, our registered official addresses are available on the Supreme Court websites, right? Like that's kind of the Supreme Court rules. So does that mean I have no protection over my name, my email address, my phone number, my office address, because that data is personal, is publicly available? So I just think how this Act is going to apply, like the very basis of the application of the Act, is sort of up to so much question, that it then means, like, what information would I even want to share if it means any company can take that data, use it for their purpose, and start processing data, share it with anybody else, and process data based on that? It will make, I think it should make everybody think twice before sharing photos and personal details about their lives. So yeah, I think that's it, to maybe at least raise some questions about the application of the Act.
Yeah, no, thank you so much, Vrinda. Prateek, do you want to take maybe like 3 minutes and come back to the RTI amendment bit?
Yeah. So if you can just go back to that slide, I think the amendments are also interesting. We've not included the one in the TRAI Act, but that's okay. That didn't say much, but two significant ones, right? In terms of 43A, and which then means that there is now there isn't a provision for users to be awarded damages in case of a breach, right? So there are penalties that are prescribed under the schedule, but that's all now go to the Consolidated Fund of India. So there isn't, so that's been taken away. Now, again, I don't think, to my knowledge, I don't think that's really been exercised, but I think just the fact that it was there was important. The other significant one is the amendment to Section 81J of the Right to Information Act, which has very significant consequences. I was on a Twitter space yesterday that the folks at NCPRI had organized, and they had an information commissioner come up there and talk about how this section is already abused significantly in terms of being used to deny information. But at least there was a qualifier in the sense that if it was in public interest, you could reveal that information. But the way the amendment now plays out, it sort of precludes any of that, right? You're just replacing it with a clause that says information relates to personal information, and that's it. So you're likely to see that a lot of information now will not be provided under the RTI Act, just using these grounds, right? And that has pretty significant implications for people who exercise that that aspect to either hold public authorities accountable to find information. We at IFF use RTI requests to a large extent to get information about sometimes about meetings, about minutes of meetings, about consultations, etc., and a whole range of things, right? Whatever we see in the news, we try to get more information out of that. A lot of those requests, I think we foresee will probably now get denied. Right, Vrinda, I know you specifically mentioned, so I think you also want to come in on this.
I was not raising my hand. I was just.
Okay.
But I mean, yeah, I just think I do agree that I think we are already seeing a dilution of the RTI, and we've sort of seen that at IFF and all, even the appeals, etc., that we draft. And I just think this is going to give such a widespread exemption clause that it will effectively be impossible to get any information, because almost all data that you seek relates in some way to some personal information. So I actually think this is really, really worrying, and the fact that it's been done in this ham-handed manner is kind of also very, very problematic. As in, when the RTI Act came, it really did come in consultation with people who had been working on the ground, and it was a real grassroots law. And I think it's been amazing in the last like 10 years, 15 years that it's been there. And I think to dilute it will really reduce the efficacy of the act. Yeah. I think we can
Yeah. No, I think with that, our presentation comes to an end. I will just stop screaming. Obviously, first off, I'd like to thank Vrinda and Prateek. Thank you for your succinct analysis. I think the audience really benefited from all your insight. I would also like to say that we at IFF are generally always looking forward to these member briefing calls, especially when something as significant as the DPDPB happens and gets introduced in the parliament, because this is sort of an internal opportunity, like an internal opportunity to an in-depth analysis on the topic, but also to engage with the community and get a sense of what it is that you are concerned about and what you would like us to do or take up in some form. So for those of you who joined today and are still with us, thank you for your time and attention. If you enjoyed this analysis, please consider becoming a member today and gaining special privileges, one of which is access to the Q&A section or Q&A part of these calls, which we will move on now to. So we can stop the live stream now.